Hey guys, Lisa Figueroa here, board certified criminal defense attorney in Florida. Here today to talk to you about the famous TikTok killer Wade Wilson, who gained notoriety after he has been convicted of murdering two women from back in October 2019. His case recently went up to the Florida Supreme Court on a very specific appeal issue. Now, you guys may know more about his case and situation than I do. This was just recently brought to my attention, and I understand that he had a long criminal history and he actually went to trial and was convicted. I believe his father testified against him and talked about some statements that he made after he supposedly killed these women.
Did he end up calling you later that evening?
Yes, ma'am.
And what did he tell you in that call that evening?
The final call?
Nope, the call before the final call.
He just told me, he did something. There was two people gone that would not be back. He said, I'm a killer. I just told him to call me back. I just thought it was another story,
So at this point, when he says that there were two people that wouldn't be with us and that he was a killer, did you put a lot of weight into that?
No, ma'am.
Did you think he was just telling you a story?
He's a good storyteller.
That seemed to be some of the most damning evidence against him, but a jury of his peers convicted him.
In the Circuit Court of the 20th Judicial Circuit in Fort Lee County, Florida, criminal action. State of Florida versus Wade Wilson. Case number 19 CF 0568. Verdict. We, the jury, finds as follow as to the defendant in this case. Count 1. First-degree murder, Christine Melton. The defendant is guilty of first-degree murder. Count 2. Grand theft motor vehicle. The defendant is guilty of grand theft motor vehicle. Count 3. Battery. The defendant is guilty of battery. Count 4. First-degree murder, Diane Ruiz. The defendant is guilty of first-degree murder.
Now the question is whether or not the death penalty should be imposed and why. So this is an oral argument. Oral argument is what happens when you appeal a case. There's a certain issue that is getting appealed in the trial court level, and it goes up to the next level, and the next level is the district court. Some issues can be asked or brought to the Florida Supreme Court specifically. I don't know if this was one that went directly. If you guys know, let me know. If this went directly to the Supreme Court because it qualifies for one of those specific reasons and they don't have to go through the second level first, or if it did go to the second district court of appeals and then it was denied and then it goes and is further appealed to the Florida Supreme Court. But what we do have here is an actual oral argument, which is an opportunity for both the defense attorney and the attorney for the prosecution, which is usually someone from the Attorney General's office. And the defense attorney is specifically an appellate lawyer. These are appellate lawyers and these are appeal judges. This is the Florida Supreme Court. And an oral argument, there's no jury. It's just judges that are not to decide whether or not he's guilty or innocent. It's usually some sort of procedural issue or error that maybe the lower court made that is being brought to the higher court's attention to have them make the final call. So that's what they're there for. It's very formal. You'll see what I mean. Let's take a look. This one's actually really short and we'll talk about why in a little bit.
All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near. Give attention. You will be heard. God save these United States, the great state of Florida, and this honorable court. Be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Wilson versus State of Florida, number 2024-1345.
Good morning. Michael Luckman on behalf of Wade Wilson. May it please the court. Seated with me at council table is co-counsel for Mr. Wilson, Laurel Cornell Niles.
I'll stop right here. This attorney, Michael Offerman, he is board certified in criminal appellate law. There's a distinction. I am board certified in criminal trial law, not specifically appeals. This is a very well-known attorney and very well respected, especially in the appellate circles. It's funny because one of our viewers had actually suggested that I watch the oral arguments in another case, the Adelson case with the killing of the FSU professor, Dan Markell, from I think 2014. And I did get to check that out, but we didn't do a video on it. But it's funny because this is the exact same attorney that was arguing that case and that motion. Let's hear what he says on this one.
If this argument had been taking place on December 17th of 2025, my presentation would be very different. But I certainly am aware of the two opinions that this court issued on December 18th. Hunt being the lead one, and Jackson perhaps to a lesser extent. I will acknowledge that all of the claims that I'm raising in my brief have been considered and rejected in the Hunt opinion. I'm very mindful of this court's time. I don't intend to waste this court's time re-arguing things that have already been considered. I continue to believe in these arguments that I've raised. Of course, I believe under Pew that my client has an ex post facto challenge. But again, this court has rejected that challenge, and the next step for my client and probably for Mr. Hunt is going to be the United States Supreme Court to consider that. So otherwise, I love a good intellectual argument, but it doesn't make a lot of sense to beat my head against a brick wall knowing that literally less than or just over 30 days ago, you've issued an opinion addressing all of the issues that I'm raising in my brief. So of course I'm open to any questions, but at the same time, the other point I was going to make, perhaps if I could distinguish Hunt, or perhaps if I could say that Hunt was somehow not argued the way that I would have argued it, but I'm very familiar with Hunt. I've watched Ms. Becheris's argument. I think she did a wonderful job, and she presented all the issues that I would have presented them the way that I would present them today, or on December 17th. And beyond that, Ms. Becheris was my legal writing and oral argument instructor in law school. And one of the first things she instructed me is when there's precedent against you, you acknowledge that precedent to the court. You preserve your issue for further review, but you don't waste the court's time unless the court is somehow interested in further discussing the matter. So with that, if there are any questions, I'm happy to address them. Otherwise, again, I acknowledge that Hunt resolves the issues in this case. I preserve these issues, and I will intend to raise them in the United States Supreme Court.
Okay, I know that's a lot, but a lot of respect for this attorney. A number of things. So what happens is these cases are put on the Supreme Court's oral argument calendar well in advance. So he didn't just find out that they were going to be there that day for their presentation of the argument on appeal, and we'll get to what they're there for in a minute. But it's scheduled for that day, and what happened is he shows up for his oral argument, and literally within 30 days of them being there, there's another case with the same argument that already went in front of the Supreme Court, and they issued an order saying no, that they disagree, and shooting down every single argument that he planned on making. So he basically is saying, I know you guys already ruled on this. There's no sense in me going through it and wasting everyone's time. Everyone's time is valuable. They have preserved it, which means we already brought up our issue and we'll reserve it to fight it, to preserve it. They're going to take it further appeal, which would be the U.S. Supreme Court. So what is this about? And he said about the ex post facto. This you can do your little typey type. Ex post facto law talks about when a law change has implications for something. How can I make it simple? Let me see. Ex post facto is a Latin word for a thing done afterward. So here what happened was Florida has this like crazy history with relation to the death penalty. Wade Wilson is and was facing the death penalty. And in Florida, it used to be, before 2016, it used to just be a simple majority. If a majority of the jurors, there's 12 jurors, if the majority, 7 out of 12, recommended death, first you have the guilt phase in the trial. Is the person guilty or not guilty? If the jury finds that the person is guilty, then they have a sentencing sentencing phase for the jury to determine should this person get the death penalty or not. And then ultimately the judge has the final say on that, but they consider the juror's recommendation. And it used to just be a simple majority. And then there was a case, the Hearst case, Hearst versus Florida, and the Florida Supreme Court said that that was unconstitutional. That was only a simple majority. And they said at that point that you needed to have 10 out of 12 jurors. That was a majority. That was considered a true majority. At that point, then it was 10 out of 12. And then in between there, afterwards, after Hearst, the Florida Supreme Court came back and struck down this 10-2 rule requiring a unanimous jury recommendation. So basically the law finally, and I think probably where it should be, is that you had to have a unanimous verdict, just like you do in a trial. You have to have all the jurors decide, not just 5 out of 6 or 7 out of 12 to decide whether someone's guilty. Well, for a death penalty and a death sentence, you needed a unanimous jury. So that's what the law was when the crime that Wade Wilson committed, that was the law. The law was you needed to have a unanimous jury decide whether or not you could get the death penalty. However, in 2023, don't quote me on the dates, but after the Parkland shooting, which many of you heard, there was a school shooting, South Florida, and after that, there was a law change. And it went back. And now the current rule is you need 8 out of 12. 8 out of 12 jurors to vote death. So that means it's easier. It's typically easier to convince a jury to give a death penalty or a death sentence in these cases when you only have to convince 8. There's a lot of people who just for moral reasons or whatever reasons, humanitarian reasons, don't believe. And I remember having a law school professor. Well, she was an attorney. I was in undergrad, and she did a lot of death penalty work. And I remember one time she told us, can you imagine, we criticize people, or we're punishing people for committing an act in this altered state where they're not in their right state of mind, and they commit this egregious act and kill someone, and that's why we're condemning them for it. However, reasonable, rational thinking people get to sit back and make a decision to then kill someone else by their verdict of voting for a death sentence. That it's just a variation of that. But anyways, that always struck me. She was clearly anti-death penalty. And while I'm not getting into that, the point is that the death penalty when Wade Wilson committed this crime, it could only be imposed if it had to have been a unanimous jury. But now, because they're applying the new law, the state only has to convince 8 out of 12 jurors that he should get the death sentence, and then he can get the death sentence. And so this appeal is based on the fact that, hey, the law changed. It should not apply to people who, when they committed their crime, that was not the law. And that makes sense to me, logically. But apparently the Supreme Court has, in this recent decision in Hunt, has said no, that they disagree and they think it's totally okay. And now it's going to be up to the U.S. Supreme Court to decide whether or not they think that that's fair, whether they think that that's proper due process and follows the law, or whether the law should change in that regard, based on the fact that at the time that he committed this crime, the law was a certain way and then it changed. So what should apply now? And that's what this is all about. And we still don't know. And he really just didn't argue it because they've already made up their mind. And he's like, I get it. I'm not going to waste your time. We're going to take it to the U.S. Supreme Court and we'll see what they say. So thanks again for bringing these new cases to my attention. I appreciate everybody watching. We'll be back with some more videos soon. Take care.